to start off with a joke because I think that's a good public speaking technique. The local Baptist, Methodist, and Catholic churches were all overrun with squirrels, and the Baptist, they tried to just sweep the squirrels out with brooms. It didn't work. They just came back the next day. The Methodists were a little smarter. They trapped all the squirrels in cages and released them in the park, but they just came back the next week, so it didn't work. But the Catholics were the smartest. The priests baptized the squirrels, and they only came back twice a year at Christmas and Easter.
That's a good one.
So, I'll tell you a little bit about myself. I was talking a little bit already, but so I just got licensed as an attorney last fall. But before that, I did my undergrad at Texas Tech in philosophy, and then I actually entered seminary. So I was in seminary for 5 years. I studied in Dallas and Washington, D.C. For the Diocese of Lubbock, and then was in discernment for 5 years, and then discerned out and discerned that God was calling me in a different direction. And I got a job. I knew Father Scott Rafe, and got a job when he was the pastor, the rector at St. Mary's up there after I left seminary, as the DRE at St. Mary's, and in 2013. And I did that and taught at Holy Cross for a while, a couple of years at the same time, and worked at St. Mary's until 2019, and met my beautiful wife while I was at St. Mary's. And we say, when people ask us how we met, we say we met at a bar at a church event. We met at Theology on Tap, which I was leading up at the time at a bar, and so and we got married in 2017, and we have 3 beautiful children, a 4-year-old, a 2-year-old, and a 7-month-old. And we recently found out that we are expecting again. Yay. Our 4th. And so due date is October. We don't know the sex yet, but we have boy, girl, boy right now. So hoping for, well, whatever, a healthy baby. But I kind of want a girl, so we'll see. Yeah, I started 2018, 2019. I loved working for the church, loved a life of service, but really thinking about my number one vocation, which is my family, and really wanted to be in a place where I could support my family. And as some of us in this room know, it's very hard to live a life on a church salary.
Yeah.
And so we started thinking what was best for our family, and decided to pull the trigger on law school. Like I said, I had some attorneys in my family, always kind of in the back of my mind. And so 2019, we packed up the kids and the Suburban, and we moved in with my wife's parents. And lived with them for 3 years during law school outside Canyon, and I drove back and forth to Lubbock for class, and it was a wonderful and difficult time, and very happy to be over with that now. So I'm happy to be here with you and not studying for the bar exam or any of that, and graduated last May, and then took the bar exam in July, and found out I passed in October, and got licensed as an attorney. And I work at Sprouse Trader Smith Law Firm, which is a law firm in downtown Amarillo, and I do general estate planning work. And so I work with people on getting their wills together. We set up trusts for people. We also do probate work, which is something I can talk about, but probate, when people pass, probating their will and administering their estate, distributing their assets how they want. And then I also do some business entity stuff with corporations and stuff like that a little bit. But I very much enjoy what I do. I find it translates well from my experience working in the church, is sitting down with families and working towards a goal. that's so much of what you do working for the church, and I pretty much do the same thing, and now doing my work as a lawyer. So I have, if you play your cards right, I have so many more Catholic jokes throughout the night, and now I'm getting some lawyer jokes into my repertoire. So this is a Winston Churchill quote I found: "Lawyers occasionally stumble over the truth, but most of them pick themselves up and hurry off as if nothing had happened." So Stephanie asked me to talk tonight and about more or less how to make a will, what is a will, kind of estate planning in general. I thought that a good overarching theme for our kind of discussion tonight is memento mori. So does anyone know what memento mori means?
Remember your death.
Remember your death, yes. This is, and I'm going to talk a lot about more later on, but in general, the idea that it's a well cemented place in the tradition of the faith of the idea of it is a good practice to contemplate, to meditate that at any moment. We were talking earlier that any moment you can step out the door, and that can be the time that God calls you. And so it's this idea of seizing what you have today and making the most of today, and am I prepared to pass? And of course the big question is, am I prepared to face God, and am I prepared to present my life before God, and hopefully be able to step into to heaven with Him, and after probably some time in purgatory, which I probably know if I'm in purgatory, I will be happy, because and so just that constant thought of so the big picture, of course, preparing for your eternal life. But then, of course, I think it connects well with just the idea of preparing for your death, and that's kind of what my whole life is right now. What my career is helping people to prepare for their death. So I'm going to come back to that later, but I thought that's kind of the overarching theme for what I wanted to talk about. And then we get another lawyer joke.
Yeah.
A lawyer woke up in a hospital after surgery. He asked the nurse, "Why are all the blinds drawn?" The nurse answered, "There's a fire across the street, and we didn't want you to think that the operation had been a failure." Okay, so in Texas, it's cut off a little bit, but that says, so this says intestate. There's an I there, but there's when you die, there's, as far as legally what happens to you and to your estate after you die, there's basically kind of two classifications. One is testate, dying testate, and one is dying intestate. And so dying testate means you die with a will, and dying intestate means you died without a will. And so we're going to talk about both of those tonight, but what are the further consequences of that? You die with a will. The most straightforward thing is everything that you own, the wishes that you have for how you want things to go after you die, it'll all go through whatever you say in your will. And you can pretty much say almost anything in your will. But if you die intestate, your anything that you own goes according to what the state of Texas says. And so the state of Texas has what's called your heirs at law, basically it's a chart of intestate succession, which means these are the people that your stuff will go to when you die, if you die without a will. And it pretty much follows, if you have a spouse, everything goes to your spouse. You have children, everything goes to your children, and then it goes to parents, and then it starts going to siblings and then cousins and stuff. And so, and that's kind of how it works. But the important point is you don't have a choice. That's just how it works. So I think the kind of thinking about talking tonight to y'all, the biggest question, because I know when I was in college or shortly thereafter, I wasn't thinking about a will or anything like that. And so why have a will at all? And you may think that, oh, I don't own anything, and actually I owe people a lot, namely student loans, and so why do I need to have a will at all? And I'll grant that for younger people who don't really have a ton of assets, it's not probably, I wouldn't put it as the most important thing in terms of, I know you said that Josh Bacchus came and talked to y'all about getting your finances together, and I think that's real important. But I think it is definitely very important. And so, so I have just a few reasons here. But one, and you may think, well, if I need to get a will, I have to hire a lawyer, and lawyers are expensive, and so I just don't have the money. But believe it or not, it's less expensive, and it's less expensive in Texas to die with a will than without a will. In Texas, we have what's called probate. And so, like I said, probate is where you, when someone dies, you take their will to the court, and you say this is their valid will. They appointed John Smith as their executor, and John Smith appears before the probate judge and says, that's a valid will, I was appointed as executor, and I want to offer this will for probate. And the judge says, okay, great, looks like it all looks good. Then the court posts the will, like literally posts the will on the wall of the courthouse, and there's a time where basically anybody who has any creditors of the estate, so anyone who says that that person who passed away owes them money, they can come and make a claim against the estate. And after that, after all the debts are paid, then the executor can start distributing the assets, or as the will said. But it's just a way to, the important thing is if there's anything titled in your name, and so anything that has a title, so you think a car, so you have a car title, anything titled in your name, and then of course, if you have a house, it's titled in your name. You really have to go through some kind of court proceeding to transfer that title to whoever it's going to after your death. And so if you have a will and you say, I give my house to so-and-so, you have to probate it under a court and have a court order and give the executor the authority to transfer that title to someone else. And so that's one of the big things. And there are certain things, especially going back to houses, in Texas, if you have a house, if you own a house and that's the house you live in, that's called your homestead, and that gives you some protections. It gives you some tax breaks. You don't have to pay as much in property taxes, but also there's certain creditors can't get to your homestead in Texas, and so even if you owe a ton of money, you may have to, the people who survive you after you passed away may have to liquidate some things. They may have to sell your car to pay back some of the money you owe, but your homestead is usually protected. And so again, so even if you owe money, but say down the line, if you buy a house, if you purchase a house, that's something that you want to pass according to your will, and you have to go take it to the court in order to probate it. The reason, and that costs money, so there's court fees, and you have to have an attorney to do it. The attorney has to be the one that presents it to the judge, so it costs money. But probate in Texas in general is pretty easy, as opposed to some other states. So you may hear in California, no one wants to go through the probate process. In California,
I bet the California's a disaster, I bet.
Yes, very much so. In California, if an attorney does a will for you and they don't design it so that you don't go through probate, it's almost malpractice. Because your stuff can be stuck in the probate system for years in California. Wow. And so it's just awful. Oklahoma is also actually really bad too, for whatever reason. And so, but Texas has a really pretty easy probate process. You take it to the court, really usually would only have to appear before the judge one time. You have to wait certain times, and there's some time markers and deadlines that you have to meet. But other than that, it's pretty straightforward. And it costs money, but it's not too bad. But if you don't have a will, and especially if you have things titled in your name again, if you have a car with a title in it, or if you own a home, it is much more expensive to administer your estate without a will and transfer that title in Texas than with a will. And so you have to do what's called a determination of heirship, and it's this whole proceeding where the court has to say, well, this person is your spouse or your kids, and they're claiming to be your kids, but we don't know for sure, so we have to do a whole process to ensure that they are who they say they are, because anyone could come up and say, oh yeah, I'm Mark Cuban's long lost son, and so I deserve to have half of what he has or whatever. So if you die without a will in Texas, and especially if you have stuff that needs to be given to other people, and especially that has a title with your name on it, is much more expensive and time consuming to not have a will. And so that's one of the good reasons to have a will. And that the second bullet point kind of goes along with that. It's easier on your loved ones because who you're leaving behind after you die is your loved ones to kind of clean up the mess, or hopefully just everything is taken care of and they can just take whatever you left to the court and go through the probate process. It's kind of a similar thing, less time consuming. Again, it takes time to probate a will, but it's less time consuming. There are things like bank accounts. There are some ways that you can avoid probate, and so if you have a bank account, you can put a beneficiary designation on the bank account and say, when I die, I want everything in the bank account to go to this person. If you do that, then it doesn't have to be probated, and so you can simplify things for people. If you don't do that and you don't have a will, it can be, we were talking about it can be very difficult. You kind of have money trapped. And so again, if you have a bank account and you don't have anything set up and you don't have a will, the people who you left behind can have a very difficult time to get to your assets. And then the last point is, I think kind of the most straightforward point is, if I have a will, I can say where I want my stuff to go to, who I want it to go to. If I don't have a will, it's all what the state of Texas says. And so that what I talked about, that intestate succession and what the state of Texas says, that doesn't include friends. So if you have anything that you want to go to your best friend, your roommate, your whatever, your friend that's been with you since kindergarten or whatever, if you don't have a will, unless you have some very nice relatives that'll just give it to them, under Texas law, it wouldn't go to them. So it goes to however the state says it should go. And then a couple other things are, you never know, you could wake up and win the lottery tomorrow, and then right after you cash the lottery ticket, you could get hit by a bus, and so you just never know. Again, memento mori. I talk about death all the time with my clients, and so I have a comfort level with it that I forget other people don't have a comfort level. And also, kind of cool thing. So one of the cool parts of my job is every now and then, again with that intestate succession, we have people that end up passing away with a good amount of money and they don't have a will. We've had times where we've had to go and find like second, third cousins and like write them like $100,000 check, and just add in someone, and they didn't even really know that person, and so out of nowhere. So you may have a long lost relative out there that you could wake up someday and you could have some money in your bank account. It worked out for you that they didn't have a will, but you don't want to not have a will and have some come into some money and then kind of be stuck. And so I think those are the most important thing. Again, like when you're younger, I totally get it. And the other thing I want to talk about was life insurance. I'm sure Josh probably talked about that a little bit, but
oh yeah, I know. There's like term and then there's full.
Yeah.
Or whole. Sorry.
Yeah, absolutely. And either one you choose is fine, and you talk to an insurance agent. That's not what I do, but I think just in general, the idea of having life insurance is a very good idea. Term is usually cheaper if you get it when you're young and healthy and not putting on the pounds like I have in my older age. It's actually really cheap, and that is another great gift that you can give to your family. If nothing else, to pay for funeral expenses. How much do you think an average funeral costs?
It's like 10,000.
Oh.
Oh,
10 to 20 to 30. It can be
Yeah.
as high as 30,000
Yeah.
with casket and burial plot and everything. And so you think, you know, if you pass away without insurance or without and then without will or anything, but you're already leaving your family with more debt, you know, to pay on your behalf. And so if nothing else, I would say go tomorrow and go to a life insurance agent and get some life insurance. You can get term for $20 a month. And then if you do that, you can get a $100,000 policy. Again, look, you know, even if you have $60,000, $80,000 in student loans debt, you still have money that that you have in your bank account when you pass, or that you want to go to someone, and it's good to have a will, you know, for that kind of thing. So those are the kind of the general. That's my pitch for wills. Now, what kind of wills are there? So in Texas, you have what you would think about, what's a typewritten document, written out. This is my last will and testament. Da 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 da. That's the standard will. That's what I would suggest to get. That's the most common type of will. But we also have holographic wills. Does anybody know what a holographic will is? Thinking of holograms.
Video of you?
What's that?
Would it be a video?
That's a good guess. No? So holographic actually means handwritten. So it's all handwritten in your own handwriting. And we'll talk more about what the requirements are for that. But you can have a valid holographic will in Texas. There are no oral wills in Texas, and most states don't allow oral wills. So you can't record, or you can't do a video recording or anything like that. So it has to be written down some form or fashion. So the requirements for a standard will, the one that's typewritten and everything, it has to be in writing. So again, it can't be spoken or recorded or whatever. It has to be in writing. It has to be signed by you, by the person who's making the will. We call that person the testator, or the testatrix. And in order to be a testator in Texas, you have to be at least 18 years of old, or in the military if you're under 18. And you have to have capacity, so you have to know what you're doing, you have to know what you own and where you want it to go. And then it has to be witnessed by two people. And I thought I'd give anyone a guess. How old do you think your witnesses have to be on your will?
21.
Okay. Any other guess?
I would have guessed 21, but I'll guess 18.
18?
I was going to guess 18 or
18 or 21? Pick one. Pick one of those numbers.
Pick
18? Okay, actually, it's 14.
I was gonna say, I was gonna say.
Yeah. But since you were the closest, you get gift card.
Whoa, nice job, Meredith.
So you have to have two witnesses to witness your will, and they have to actually see you sign it, and you have to see them sign their name, and they only have to be 14 years old.
Wow.
Now this is the type of thing that you really need an attorney to do, and these are kind of the general requirements, but there's very specific things, and when you sign your will, it has to be done in a very particular way. This type of will, and it's kind of easy to mess it up. And the last thing you want is for you to think that you have a will and actually not have a will. And so we've had clients that come to our firm, people, grandma passed away, and they bring up a document and they say, here's her will, and we look at it, and it was signed by one person. One of my partners in my law firm said the biggest heartache he has in the office, the worst news he has, is when someone gives him a will, he looks at it and says, this isn't a will. This is nothing. And so that person thought that they had done everything right and had very specific. They gave family heirlooms to specific people, and it's nothing. They don't have a will. And so this is the type of thing that you really do need an attorney for. I forgot. I need to give a disclaimer because I am an attorney. Nothing that I say tonight is legal advice. I'm just giving general kind of advice or general, guidelines and general information about what a will is and what estate planning is in Texas. But I'm not giving you legal advice. I'm not your attorney. We're not forming an attorney-client relationship. So if you do want an attorney, you have to come and you have to see an attorney in an office and sign an agreement saying that you're going to be my attorney. And that can, I'd be happy to do that for you, but anyone else, and I'm not in any way saying that you have to employ me or anything like that. But I have to say that for ethics rules and because attorneys are anal like that. So, okay. I think that's all, but yeah, so this is the type of thing that you want to get an attorney for if you want it. And it's not cheap. If you came to me for an attorney, or if you came to one of my partners and you just had you needed the most basic will, they'd probably charge you $1,000. I'm new. I could probably charge like $800, but it's not a cheap thing. But in the long run, hopefully it's worth it. And like I said, that is cheaper than dying without a will and kind of leaving a mess. And like I said, that process of needing to transfer property and without a will after you die, that goes into $1,500, $2,000, $2,500 easy just to do that. And so it is actually cheaper to hire an attorney to do a will and make sure it's done right than to die without a will in certain circumstances. Okay. Second type of will is a holographic will. So a holographic will, the requirements are, again, it's a writing, nothing, no tape recorded wills. But it's all in your handwriting and it's signed by you. And so solely your handwriting, and a signature can actually be anything that you intend to be your signature. So it could be an X, it could be whatever, as long as you intend it to be your signature. But this is, and it doesn't have to be witnessed by anybody. You can do it in your room by yourself. Doesn't have to be notarized.
Isn't that sketchy?
Yeah, so it can be, and so we're gonna look at some examples in some holographic wills. But there's a lot of law, like this law in Texas has developed over 115 years of, and this is kind of just a way that the law has acknowledged that you can't always get in front of an attorney, and you can't always get in front of two witnesses, and you can't always get in front of a notary or whatever. But it's that important to have a will, and so the law allows for this kind of this other option. It's kind of like an emergency, technique, so that someone can have a way to make their wishes known and direct their property after they die.
So basically, you're saying, well, on the ethics thing, you're saying that, say I just write, I want this and this and this and this to go to this person and blah blah, and I sign my name and I die, and someone's like, oh, there's this letter from Timothy on the table in his room, and that's his will?
That could be a will.
What?
Yeah.
Okay.
So what?
Okay, I mean, to pay $1,000 to get a will done, and then I can do one for free in my room. I mean, what's the?
So one thing is, if you do this type of will, when you pass, this is a more expensive type of will to probate, because it's not as reliable, because we don't know if it really was you.
Yeah.
There's a much longer and more expensive process that the court has to go through, and there has to be witnesses brought in. Whoever's survives you, has to hire an attorney. You have to have witnesses brought in about handwriting, and you have to put on evidence. It's like a trial, basically. And you have to prove, and it's on the burden of the person bringing the will to the court, saying, "Oh, this is their will." That person has to prove that it actually is your will.
Okay.
And so that can be, the costs of that can really, add up. But at the end of the day, it can be a completely valid will, as long as it's all in your own handwriting and signed by you. So that's why, and so that's the main reason why I wouldn't say, in general, all things being equal, this probably wouldn't be the route that I would suggest to go, because it can be, and again, it could have been your will and you wrote it down, but the person who brings it to the court, maybe they don't meet their burden to prove that it was, and the court's not convinced, and then you're back in that boat where you thought you had a will and your legal will behind you actually didn't, type of thing. So I'm trying to think of like an example or it's just, you can kind of do things, you can do it this way, but it's like triage, it's not, it's like, it's kind of like putting a Band-Aid on it, but really you want to go to a doctor and get, the tests done and have everything kind of done, have everything lined up and, dot your I's, cross your T's type of deal. But with all that said, again, this can be a completely valid type will, and I'm going to talk a lot more about holographic wills in 1 second. But first, if you want a will,
oh my goodness, dude, what?
So if you want a will, your options are to go to an attorney and get the kind of formal standard will, and they'll write it up and they'll make sure that it's all done correctly, so there's no issues, and it'll be signed by 2 witnesses and notarized, and you'll, like I said, again, you'll pay money, but you'll have peace of mind that that's ironclad and it'll be fine. Or you can do a holographic will, all in your handwriting, signed, and let someone know, and that can be great. But what not to do is don't go onto the online and try to download something, and don't ask Chat GPT to write your will for you.
Dude, that would be so bad.
You can ask it, but don't think that that's anything. That's nothing. So, that's kind of a joke, but there are you've heard of LegalZoom, and there are websites where you can go and download a will form, and my non-attorney advice is don't do it. It can cause so many problems, and some of that, in some states, those will forms are okay, and can kind of be considered a holographic will. But in Texas, if you have if there's more printed stuff on the page than your handwriting, then it's not going to be considered a holographic will. The best thing in Texas is everything is in your own handwriting. We have so many issues. We have people that come to us that things have just gotten into a mess because they used LegalZoom or just downloaded something online. So I would not advise that. It can just cause a lot of problems. Okay, so holographic wills. So if you go to www.texasbar.com and you search for holographic wills, this is the state website for the bar. This is the Bar Association's, the Association of Lawyers in Texas. This is their official website, and they have a whole article on how to write a holographic will, and very detailed, more so than I went into. I did a QR code that links directly to the specific site page I'm talking about, and so I can leave that up later if you want to scan it. But it'll show you. There's an article there that goes into detail about how to write a holographic will. Again, I'm not advising you. I'm not telling you that you should do that. I'm not telling you necessarily really how to do that. So, just from what I told you tonight, don't go home and think that you can write a holographic will and Kelsey, the attorney told me to do that and told me how to do it. So you need to do more research if that's something you want to do. Again, I think that is a good if nothing else, I totally get it. If you don't have the money to pay an attorney, to write a will for you right now, it's not a bad idea. And I actually did this when I was in law school. I wrote my own holographic will, and especially because I had children and I wanted to make sure everything was taken care of. And it's kind of a good fail-safe to have that and tell someone, okay, hey, I wrote this down and it's in the top drawer of my desk. And so if nothing else, you kind of know that, well, at least that's there, and it has a good chance of, if it has a good chance of being probated and being my will and everything and stuff. And so, especially kind of, in college or just out of college, it's not a whole lot of money. This is not a terrible option, but definitely when you start getting more assets and get a house and get a car and stuff like that, this is not something you really do need to get a standard will with an attorney and make sure everything is done fully correctly. Okay, so we're going to look at some holographic wills. So this is an example of a holographic will that was admitted in Texas and was a valid will. So it's just on this post-it note. I hope that you all are fine. I am not feeling well. I am not feeling well, F-E-L-I-N-G. Everything I own goes to my sister, Norma, XOXO, Betty Williams. And that was a will. So it can be as simple as that. Here's another one. Everything to my sister Rebecca, love you, so-and-so. So this was admitted and the court approved it as a will. Here's another one on a shopping grocery list. This one has more stuff to it, as you can see, but that was admitted as a will.
So if you put like a phone number and things, is that more likely to?
Maybe. I mean, that could be evidence that it was really you who wrote it, but I would say necessarily a phone number or not, but if the more you put down and put that my name is so-and-so, this, I intend for this to be my last will and testament, and da-da-da-da-da, and that gives it more of a chance of the court approving it as your actual will. I thought this one is funny and sad at the same time. So it says here at the end, I have 3 boys and grandkids I have not seen in years, and it says, if I see them before I die, and then that's crossed out, and it says, I do not want them at my funeral. Aww. Yeah, so it's kind of sad. This one was a greeting card. So this was actually an attorney who sent a greeting card to someone, and on the back of the greeting card, he put, last will, I leave everything to Vanessa, and he signed it. And then he put, this is pursuant to my incomplete will, but the court actually found that, they couldn't find, apparently he had started an actual will, like a formal will, and didn't finish it, and so he just sent this greeting card, and then he passed away like not too long after this, and they never could find his incomplete will, so they just used this as his will.
Wow.
Okay, we're gonna play another game.
Oh my God.
Will or no will? So these were scenarios that in Texas were presented to be as a will to a court, and it's up to you to decide if the court accepted it as a will. So, written in blood on a wall, who thinks it was a will? Okay. Who thinks it was not a will? Okay.
No. What?
What in the world, dude?
It was a will.
What?
They took photos of it and presented it to the court, and they had a whole trial and proved it up, and it was a will.
Wow.
So this one, a painter was on scaffolding on a building. The scaffolding broke, and he was hanging on for dear life, but he was able to scratch something out on a plank on the scaffolding, and then he fell to his death. And the plank was presented as a will. So will or no will?
No,
I'm gonna go will then.
Wait, what are you asking? You said will or
Will.
no will, and
sorry.
everybody raised their hand.
Sorry.
Oh,
So was this a will? Raise your hand if you think it
okay.
was admitted as a will
Well,
of court.
If that first one was,
Okay.
then the second
Raise
one.
your hand if you don't think it was admitted as a will. It was a will. So, this is my last one. There you go, sir.
thank you.
Spoken into a tape recorder right before a tornado hit.
No.
No,
No, why?
because you can't. It has to be
Yeah.
written down.
Exactly. There we go. Y'all are paying attention. I love it. And then this was in one of my textbooks from law school. This was a holographic will, so it's typed out here because it's in my textbook, but this was written out, and it's just kind of funny. So it's all kind of broken, and it's really, there's weird periods and stuff. And then I love the last part. So it says, so I ask you to use special care in selecting a lawyer to attend to this will. Don't get some grafter, as most of them are, who will rob you out of your eye and teeth and then pretend they are your friend. A lawyer is more deadlier than a rattlesnake, so look out. And I would say not bad advice. And then it says, I pray and hope you don't go through life single and alone. So she wrote this to her friend as a letter, but it was also her last will. I hope you find a loving husband and dutiful children. Don't give 1 cent to kinfolks, priests, nor preachers, nor any churches. Remember, give where it will do good. Reach out to the suffering, helpless, and sick people, and let this property I leave do you some good. So I recommend charity, not kinfolks. Just because I'm passed on, I expect you to hold all I've requested herein made, and I do hope and pray that you have the grand noble spirit to carry them out to the letter. I hope in God in heaven will always watch over you and give you his protection. Your true loving friend, Rosa. Again, so she wrote all this out in handwriting and signed it, and it was a will. So that, any questions? That's the last on holographic wills. Any questions on that before we move on?
I don't know if this is a good spot to ask
Yeah.
this. Has it ever happened where like they couldn't find a will, or they didn't know of a will, and then they went through the process and then found a will?
Yeah, so there have actually been times where people have probated, so when you probate a will, you have to probate the original copy of the will that has the wet ink on it that you signed, but generally. But you can probate a copy of the will. And there have been cases where they probated nothing, but they said that we know there was a will, and so they presented evidence of people that said, yeah, I was there, I saw him write it, and I saw him sign it, and I signed it, but they just can't find it, so that has happened, yeah. But that's very rare. And there's other stuff, again, like, I don't want you to think that, I did this because I think it's neat, and it's kind of interesting, and funny, and stuff. Everything I showed you is the exception to the rule. And again, even just, it's technically a will to write on one sentence. I give everything to my mother and sign it. It's saying a will, but it does create a lot of problems, like I talked about earlier about proving and everything. But also, like in a standard will that we write, even if you came to me and you said, I don't really have anything, but I'm just going to say everything I want to give, I give to my parents, and that's all you say. That's still going to be like a 7, 8, 10-page will that I'd write for you. Because there are all these formalities and things, and you have to name your executor, and you have to say whether you want an independent or dependent administration of your will, and you have to say whether you want your executor to post bond, and all that stuff has to be, the court has to determine that after you pass, and if you don't put that in your will, the court's going to decide for you, and the cost can rise, and like I said earlier, probate in Texas is really easy. but it can be difficult if you don't have some of that stuff. So for example, there's what's called in Texas a independent administration and a dependent administration. So when you go and your grandma passes away and you give the court her will, if the court says they want to do a dependent administration, that just doubled the cost and doubled the time that it would take to probate that will. And so we make sure in all our wills we always say independent administration, and that's something that we just know from experience.
Why would you do, wait, so obviously though what you just said, it's more expensive, more time. But what's the other is there any other differences?
So so you would do a dependent administration if there was controversy, if there were kind of family members fighting over things.
Oh.
If the person who you named as your executor, and the executor is the person you name in your will who's going to be in charge of your estate after you die, and it's their job to take the will, and it's their job to distribute everything. But if your executor doesn't want to do it, and the person you name as your backup executor doesn't want to do it, sometimes the court says, okay, well, we're going to just name like a bank to do it, or one of your creditors, and it's going to be a dependent administration, and the court has to approve every single thing along the way. And so there can be times to do it, but if you can avoid it, you do, and that's why you want to come to it. And there are lots of things like that an attorney will know about, but no one else. You wouldn't have reason to know about if you're just a normal person.
Can you do a holographic will several times? I mean, if you
So you can only ever have one will, and so that's another thing is all of our wills. And if you did a holographic will, you'd want to one of the very first things you want to say is I revoke all prior wills.
Okay.
And we do, of course, we have people are regularly updating their wills. They come to us. We did a will for them a few years ago. They want to update. Some things change. So we put that in the new will. I revoke all prior wills, and then we actually ask for the will, and we destroy it. And so it's clearly, because you don't get to a situation where people are bringing multiple wills to the court after you die and say, no, this because you could have given everything to your brother in the old will, and now I'm giving it everything to charity or whatever.
Oh.
And then your brother shows up and says, no, actually this is the true will, and that stuff happens all the time. But yeah, you can do as many wills as you want, but you always want to make sure that what the most recent one you did is the will that you want, and that you revoke any prior wills.
I presume this is understood, but you would want the date on it as well?
Yeah, and again, that's not a requirement, well, either for either a standard or holographic will, but you definitely want the date on for that reason, so you can say which one is the most recent. And again, that's not definitive evidence, because you could write the wrong date, and but it is evidence that this is the most recent will.
So if you did go and get a will done with an attorney, and then you wrote a holographic will revoking that, is that still potentially valid?
Mm-hmm. Yep. But not recommended. If you ever revoke a previous will, destroy it. Destroy the previous will. Burn it up or rip it apart. Okay, so that was kind of that's all I was going to talk about with wills. But we also do, so if someone comes to me and they say, I want to get my estate plan together, we can talk about a ton of things, but we talk about wills. We do a lot with, I don't know if you've heard of the estate tax, and so estate tax is also known as the death tax, and it's the government's one last chance to get money out of you after you die. And so if you have the assets in your estate or reach a certain number, then the government says, okay, we're going to tax your estate, and you do not want the estate tax. It's a 40% tax, so basically almost half of your stuff goes to the government. It's not something most people have to worry about, because you have to be very wealthy in order for it to be a problem. But as there have been times in history where the estate tax threshold has been really low, and so a lot of people have had to worry about it. And if you have a life insurance policy for $500,000 or $1 million, you can get a life insurance policy for $1 million and it costs like $50 bucks a month. I'm sorry. Then you could have a estate tax problem. In the past, you may have had an estate tax problem, but that's something that we'll talk about with our clients. But so we talk about that, and there's lots of things we do with wills and trusts and stuff. But we also talk about what we call our ancillary documents, and these are not death documents per se. These are documents for you while you are alive, but they're documents that if you are alive but you can't communicate or let your wishes be known or for some reason. So this is called a power of attorney. There's one called durable power of attorney, medical power of attorney, advance directive, and then if you have children, designation of guardian for children. Durable power of attorney is basically your financial power of attorney. So if you're in a coma, you can't communicate, you need someone that can sign checks and keep the lights on and pay your bills, and this is the person that can do that. So you give someone the power of attorney to make financial decisions on your behalf. Medical power of attorney, the same thing, but for medical decisions. Again, you're in a coma, you can't talk, you need someone that can make medical decisions on your behalf, and the medical power of attorney is the person that can do that for you. So these are people that obviously that you want to trust because they actually have a lot of power. They could.
Okay. Are you, I don't know. Are you going into those or very deep, very much? Or is it
no, that's more or less it. So yeah, you have a question?
Well, okay. So I did my medical power of attorney using Rocket Lawyer.
Okay.
Is that okay, or what's your recommendation? Like, because so it gave me the form and everything, and it put all the information in, and I printed it off, and I had to go get two people to when I signed it, they had to be there to when I signed it. So I did that, and I put the date when I signed it, and they were there. And they put the date. They put their signatures. So was that valid?
So I'm not going to say yes or no.
Okay.
Because I can't give you advice.
Okay.
But what I will say is, what I was talking about earlier about wills and how you have to make sure your wills are done the exact right way, and that's why you don't want to use online stuff.
Yes.
Because wills are very particular, have to be done a very particular type of way. That's other documents, including these documents, aren't as particular, and so it's not as essential that you necessarily have to get an attorney to necessarily do this stuff for you as is a will. So that's all I'll say. So yeah, without knowing, without looking at what
Right.
I can't give you a yes or no answer. But if you have any doubts, you may talk to an attorney just to double check. But it's very important with wills not to use online stuff. With other stuff, it just could depend, but it could be. It's not as you don't have to be as particular.
Okay.
So yeah, so these people you want to trust, and they can make decisions for you on your behalf. And this is the type of stuff like you can take the hospital with you if you're expecting surgery or something like that. Like, we did one for my wife and I when she had our most recent. I made sure we had all this stuff with us and gave it to the hospital so they knew. Now, generally, most hospitals, if you're in a coma, they're probably going to talk to your parents. If you're married, they'll talk to your spouse. But it's just good to have it in an official document in case there was any controversy or anything like that. So an advance directive, sometimes called a living will, sometimes called a directive to physicians. This is a different document. This is where you are saying what you want your wishes to be and for certain medical scenarios. So this is where it's saying basically, if the doctor says I have 6 months to live, this document says this is how I want to be treated. I want to be kept on, I want every available treatment to be given to me to try to keep me alive, or basically keep me pain-free as much as possible, but let me go. And this gets into, let's see, how do I get out of the slideshow? I'm not good with this. Let's see. Oh, I gotta talk. So, this gets into church teaching a little bit, and so end of life stuff. You know, the church has very specific teachings about end of life and the moral way to treat people when they are end of life. And so, I actually wrote up some documents that we use at our firm for specifically Catholic clients if they want it. Like this isn't a full medical power of attorney. I just took an excerpt from it, but this is language that we put in our medical power of attorney that says, yes, I'm giving this person to be my agent. They can make decisions on my behalf, but I want them to follow church teaching. And so, essentially, what that comes down to is the church basically says that if someone is at the end of their life, food and water, nutrition, hydration are always just an ordinary means of keeping someone alive. And so, all things being equal, it doesn't respect the dignity of the person to let someone die from starvation or from lack of water or lack of hydration. And so, the hospitals and even the state law don't line up with that, and so they consider food, nutrition, and hydration as extraordinary means of keeping alive. And so if you just sign the document that we typically use, a power of attorney or the director of physicians that you can find, that's a pretty standard document, that doesn't follow church teaching. And so it would consider food and water as an extraordinary means. And so when you say, oh, keep me painless, but let me die as gently as possible, if you don't have language like this in that document, the hospital will read that and say, oh, okay, well, we're going to give them morphine and, so they don't feel pain, but we're not going to give them food or water, necessarily. This is something as part of our faith that's important when you are doing these documents to have. And again, it's not, if you have a parent there or a spouse or a sibling, a hospital is usually going to, talk to them, and if you're clear with a close family member about what you believe and what you want, how you want to be treated, usually, unless there's a controversy, a hospital will go along with what they say. So this is again an excerpt from our advanced directive, and this again is stuff that I put in for for Catholic clients, and basically again just says I belong to the church and I follow church teaching. And so, and this also says, if I'm in a place where death is imminent, I wish for a priest to be contacted so I can get last rites. Again, that's important so that they know that that's something that's important, because obviously much more important than our body is our eternal soul. So, I know I'm kind of going long, but I just wanted to show you all those. Let's see. Okay. So that's it on the ancillary documents. Any questions on those? Any other questions?
On the medical power of attorney, because I think I remember, like, if I've gone in for surgery, do they give you one there, or?
So I think oftentimes they'll give you like a DNR or an advanced directive, but typically I don't think that they would give a medical power of attorney. A medical power of attorney usually needs to be notarized.
Oh, okay.
That's been my experience. Is the hospital probably wouldn't, because that you're really giving a lot of power to that person, and hospital wouldn't. So, but the advanced directive or DNR, you're not giving the power to anyone else. You're just saying these are my wishes, and so. But again, in these documents too, like if you came to us or or another standard estate planning attorney, those documents would say, I revoke, if I have any of these other documents, these are the ones that I want, I revoke any of these other, if I've done this in the past.
Is that the only place to get a medical power of attorney, is through an attorney?
No, so these, you can actually go to the state the state of Texas legislator, trying to think what the website is, but these are forms that the legislator in Texas actually put into the statutes, and so these are fully online and available. The official state of Texas ones are online.
And they're state of Texas?
Power of attorney.
Okay.
So durable power of attorney, medical power of attorney. Again, of course, like I said, these wouldn't necessarily align with church teaching. They're not necessarily against church teaching, but don't have the extra language in. But these, I didn't talk about this, but advanced directive, you can find them online, but it's not from the state of Texas. But again, it's not, I wouldn't say never go online to get this stuff, like I would or will.
Okay.
This is something I threw in, and of course this is very important for parents, and this is something else that we do.
My parents did that.
Okay.
Like they had that put in there.
Yeah.
Yeah.
Because we always, as attorneys, we look at the worst case scenario. That's our job, and so, we have a young couple that comes in with kids, and they can leave our office and get hit by a car, and they're both gone, and you know what? And so, we like to do these documents as well. Do you have a question, or you?
Yeah,
Oh, yes.
so the advanced directives, I might be misunderstanding exactly what it's for, but can you add things in there for like if you're going to the hospital to give birth, like can you add things in like with church teaching on like how you want, like if something goes wrong with like your pregnancy or
Yeah.
giving birth?
So there's a space in the advanced directive where you can add your own specific wishes and instructions, and like the form that we use literally just has like blank lines that you can write in, and so yeah, you can definitely do that.
Could you even do that like, I don't know, like, cause we have, do you know Tim and Rosanna Omis?
I don't think so, no.
Oh, okay, so
Who is it?
You know
it's
Clara. Hannah
Alina's
Omis?
parents.
Oh yeah.
Yeah.
Omis. I didn't hear you say Omis.
Omis.
Yes. Okay. Yeah. Sorry.
Yeah. So, like Roseanne talks about like how she like signed a paper or something telling them like don't even mention abortion around me, don't mention anything like that. Like
Yeah.
is that part of something over here?
So,
Or maybe just something in her own personal chart or something?
yeah. I'm not quite sure what she was referring to, but I think if you wanted to do that, so advanced directive really looks more like end of life stuff. So the form that everyone uses, it kind of gives you two options. It says if I'm in a they call it, and this is from the state of Texas does have a version of this that you can find online, but you can find different ones. But the state of Texas version is if I'm in an irreversible condition or a terminal condition. The way they define that is, I think irreversible is the doctors say I'm gonna die soon, but it could be more than 6 months, it could be 8 months, it could be a year, whatever. Or maybe I'm getting those confused. And the other one is I'm gonna die within 6 months. I can't remember if that's terminal or irreversible. I'm getting confused, but essentially it's two options. I'm gonna die. It may be longer than 6 months, or it's the doctor saying it's going to be within 6 months. And then for each of those scenarios, you can say, I want use all available means to keep me alive, or keep me painless but let me go. And it's essentially the pull the plug kind of scenario. So advanced directives look more like at end of life stuff, but you could definitely put it in there. I would say, like, definitely if you have a medical power of attorney, like I said, like, we put Catholic stuff in there, and you can put it in there and make that known. But I'm not sure, what she was talking about, other than, I don't think it's a bad idea to just, you could
Say
just,
it everywhere.
just say it everywhere. Yeah, absolutely, 100%, yeah.
Is there an expiration date on any of this?
No, so death.
Okay.
So you can put an expiration date. We usually don't.
Yeah, whenever I did it said, how long do you want this to be in place or whatever, and you could put a limit, or you could just put forever or whatever.
Until you revoke it. And you can revoke it at any time. Especially with the powers of attorney, it's you are giving those powers that you have by law to someone else. You still have them, but that person has them too. And so you can revoke it anytime. You can even revoke it verbally and say, no longer give that to you. I would suggest doing it written too, but that's why it really needs to be someone that you fully, completely trust 100%. And you can put an expiration date on it, but we typically don't because, again, the medical power of attorney, it's for an emergency. And so, why, unless there's a very specific, I just want it, I'm going in for a major surgery or something. But in general, you give your power of attorney to someone so that when you are rushed to the ER in a car wreck, that person, the hospital can call that person. And so you don't know when that's going to be, so it's hard to put an expiration date on. And there are powers of attorney, medical power of attorney that you can say, they're called springing power of attorneys. They don't start as soon as you sign it. They start when you become incapacitated. But that is also very difficult because you have to have two doctors to confirm that you're medically incapacitated. You can't speak for yourself or whatever. And again, in an emergency situation, that doesn't really do any good. So,
is there ever like a way to do like two people?
You can do co-agents. If you do co-agents, we typically suggest giving each of them full authority so they can act. They don't have to get the consent of the other one. That it doesn't have to be like a majority rule type deals. But yeah.
So I can say, I want Mary and, Susie, who are like, say, my sisters or whatever, so they can both do that.
And they can be co-agents, and then we also do like a list and like successors. And so, and it can even be like, call this person first, but if they're not available, you can't get a hold, then call this person.
Okay.
Or if this person has died or they were in the car wreck with me, then go to this
Right.
person and then go to this person.
Got it. Okay.
Okay, that was my question, because I was like, what if it happened like at the same time, or they had just died and then you die, and it's like, okay, now no one knows what to do.
Yeah. So we don't typically do co-agents just because it could get messy if they don't agree on what they want. So more so, we typically do a succession list, and so
That's the way mine was succession.
and that's pretty standard. Any other questions about this stuff? Okay. Yeah, and that's pretty much it. And then I was just going to talk about Memento Mori a little bit. It's perfect theme during Lent, but the whole idea of remembering your death, live for today, and pray for a good death. The saints all talked about praying for a good death. That's one of the biggest graces you could have, is to have that peace at the time of your passing, to be confident that you can face God and ultimately it's all God's grace and mercy, but we want to put ourselves in the best position that we can to live a good life and ultimately be saints with God in heaven, and all of our ones that have gone before us. And so, monks and still today, but monks would have a skull on their desk, and for this reason. So if you see like paintings of monks and stuff, they often have skulls on their desk, but it's for this reason: memento mori, remember your death. Constantly, every day, they would meditate on this idea that. And it's not macabre. I mean, it can be macabre or stuff, but it wasn't. They weren't doing it out of like a sense of macabre or ghoulishness. It was a holy meditative practice to remember that ultimately, and like from Genesis, you are dust and dust you shall return. Again, Lent is a perfect time to think about it. We are not guaranteed, and everything is a gift. Every second we have on earth is a gift from God. And God can choose to take us at any point, and that's His total right to do. And so every single second is a blessing and a gift. And our lives are not our own; they belong to our Father and to our Maker. So, this is a great quote from Saint Alphonsus Liguori. But you can find this saint. I did another QR code. It's a Word on Fire article, Bishop Barron's thing about memento mori. I'll just go ahead and end with this. And you, my brother, how are you spending that time? And for what reason do you put off until tomorrow that which you can do today? Remember that the time which is already passed away is no longer yours. The future is not in your power. The present time alone you have for doing good. St. Bernard warns us saying, "Wherefore do you presume upon the future, O miserable one, as if the Father had put the times in thy power?" And St. Augustine asks, "Do you reckon upon a day who canst not reckon upon an hour? How canst thou promise thyself the day of tomorrow, if thou knowest not whether one more hour of life will be thine?" St. Teresa thus concludes and says, "If thou art not ready to die today, thou oughtest to fear lest thou shouldst die an unhappy death." And so, I think that's just a good, if you embrace all things in this life as coming from the hands of God, and even embrace death to fulfill His holy will, assuredly you will die a saint. So, that's it.
Awesome.
Yeah.
Thank you.
Any other questions, or? I talked a long time.
You did good.
I didn't think I was going to talk that long.
Did you got a copy of that? Or, oh, you're taping.
Mm-hmm.
Yeah, I want that.
Oh, I can take a picture.
I'll email that.
Oh, perfect.
Yeah, to Stephanie.
Perfect, yeah.
I probably won't email some of the other.
No, I just want,
stuff,
yeah,
but
that. So,
Whatever you want.
because by the time I write it,
Yeah.
Thank you. You answered a lot of questions.
Oh, good.
Thank you.
Yes.
Thank you.
That was really good
Good.
Yeah.
information to put away.
Yeah. Yes. Yeah. Again, like I said, I'm not going to say you have to go out and get a will tomorrow, necessarily. But it's something good to think about and, be aware of. And, but especially if you do have stuff that you want to go to people, it's not a bad idea to do. So, there are some people that I would tell them, I think you need to get a will tomorrow, but thank y'all. Thanks for asking me.
No, thank you.
Yeah.
You
What was
make it help.
what was your firm? You work for?
Oh yeah, Sprouse Schrader Smith. And so I have some business cards up here. I'll leave up here if you want to grab them. You're welcome to. If not, again, I wasn't coming here to tell you that you have to come to our firm, or I'm not this wasn't an advertisement. This was just to be here and to hang out with y'all and talk about some important stuff. So
Thank you.
yeah, absolutely.
Thank you for the legal advice.
No, I did not give you legal advice.
Oh, sorry. I
Not
thought you
giving
said
legal advice.
Oh, my bad.
He's like, let this get straight.
Oh,
right now.
sorry. Oh,
Nothing I said tonight was legal advice.
whoa. I
It
thought
was,
so. Oh,
Thank you
okay.
for the
General
friendly
information that you can find online anywhere.
No,
I
very,
am not your
very.
lawyer.
Okay, glad I got that straight. Okay.
Very, very informative. Very,
Okay.
yeah, stuff I had no clue.
Thanks for the pizza.
Oh yeah,
Oh, yeah.
of course, yeah, absolutely.